Social media users have criticized former President Donald Trump harshly for reportedly planning to sue the court in his Manhattan hush money case. Citing court documents that were not yet public, the New York Times said that Trump was preparing to launch a Article 78 action against Judge Jon Gabrielsen, who is presiding over his criminal trial in Manhattan. Judges and government entities can be challenged by citizens under a specific action that is governed by New York state law. The Office of Manhattan District Attorney Alvin Bragg is prosecuting Trump on criminal counts related to claims that the former president illegally fabricated financial records to hide alleged payments made to adult film star Stormy Daniels to silence her about an alleged 2006 affair. Trump has entered a not guilty plea to the allegations against him and denies having had an affair. The Manhattan case is the first of Trump's criminal cases scheduled for trial on April 15th. Despite the opinion of some legal experts that it is the least noteworthy. Trump has been criticizing Judge Gabrielsen more and more on social media as that day draws near, accusing him of being prejudiced and unbiased against him and demanding his recusal. In the midst of these attacks, some of which have even targeted the judge's daughter, Gabrielsen has extended a gag order against Trump, but the former president has persisted in making them. Trump intends to use the action to persuade an appeals court to postpone the start of the trial and break the gag order, according to people familiar with the situation who spoke with the Times. The outlet pointed out that it is unlikely to be beneficial for the former president and that the appeals court might move swiftly to reject it. Following the report's publication, a number of comments appeared on X, the previous Twitter platform, criticizing Trump and his group for being desperate. Legal commentator Harry Litman wrote, Trump's most recent desperate move, suing Gabrielsen personally in the appellate division, is reminiscent of his initial gambit in Palm Beach, where Judge Cannon permitted him to take the whole action off track. This won't happen, though. What if a criminal defendant was capable of doing this? Trump intends to sue Judge Gabrielsen to postpone the hush money trial regarding election interference, tweeted Allison Gill, the presenter of the Mueller, She Wrote podcast. It is not going to work, but that's desperate, man. Writer John Hudson stated in a different post that Trump's legal stunt, suing the Manhattan judge in his criminal trial there, won't work. Just another delaying tactic and a pathetic attempt to look like a victim. Moreover, a financial analyst has stated that Donald Trump is going to be in a world of hurt if he cannot raise $175 million in bonds by next Monday. Market analyst Jon Gabrielsen, of Atlanta, told Newsweek that in the event that the former president is unable to post the bond, New York Attorney General Letitia James could simply seize funds from Trump's accounts. The court dismissed the documents pertaining to Trump's $175 million bond due to its inability to confirm the insurance company's financial stability. The court has set a deadline of Monday for Trump and the insurance provider, Knight Speciality Insurance, to provide proof of funds for the bond. James may file an enforcement action against Trump's property if that isn't the case. In an effort to keep James from taking control of his assets while he works to defend the civil fraud verdict against him, Trump posted a $175 million bond on April 1st. Trump, his adult sons Donald Jr. and Eric, as well as the Trump Organization, were previously found accountable by New York Judge Arthur Engoron for a conspiracy in which the value of Trump's assets and net worth were illegally overstated in order to get more advantageous commercial deals. The presumed GOP presidential candidate for 2024, Donald Trump, has insisted on his innocence in the situation. In order to prevent the state from seizing his assets, including his numerous real estate holdings, Trump would have had to post a bond somewhat greater than the $454 million penalty that was assessed, plus interest. Subsequently, an appeals court decided that he may instead pay a $175 million reduced bond. Not long after it was deposited, the bond was rejected by the court's filing system because some documents were lacking, like a current financial statement. James subsequently questioned the sufficiency of the bond and pointed out that Knight Specialty Insurance Company, KSIC, the surety supporting it, is not admitted in New York, which means it is not qualified to receive a certificate of qualification from the Department of Financial Services. James' office led the fraud case against Trump. As a result, KSIC has refiled its documentation in an attempt to restart the procedure. Gabrielsen claimed that if James seizes the float that all businesses need to cover their ongoing costs, Trump's businesses won't be able to support themselves financially. Furthermore, according to a renowned real estate attorney, if Trump does not post a bond by next Monday, the New York Attorney General might begin seizing his belongings. Paul Golden, a partner at the New York law firm Coffee Mautica and the author of Litigating Constructive Trusts, told Newsweek that a move certifying that a $175 million bond has been issued must be filed by Monday by either Trump or a bond company. Presumably, if the motion fails, the Attorney General will take the position that the bond is without effect and that the Attorney General may start to take collection efforts, Golden stated. Of course, if for whatever reason a court rules the bond is without effect, then Trump would likely appeal that decision as well, and possibly seek a stay in the context of that separate appeal too, he stated. In an effort to keep James from seizing his assets as he works to fight the civil fraud ruling against him, Trump posted the $175 million bond on April 1st. Trump, his adult sons Donald Jr. and Eric, as well as the Trump Organization, were previously found accountable by New York Judge Arthur Engoron for a conspiracy in which the value of Trump's assets and net worth were illegally overstated in order to get more advantageous commercial deals. The presumed GOP presidential candidate for 2024, Donald Trump, has insisted on his innocence in the situation. In order to prevent the state from seizing assets, such as numerous real estate holdings, Trump would have had to post a bond slightly more than the $454 million penalty that was assessed to him plus interest. Subsequently, an appeals court decided that he may instead pay a $175 million reduced bond. Not long after it was deposited, the bond was rejected by the court's filing system because some documents were lacking, like a current financial statement. James subsequently questioned the sufficiency of the bond and pointed out that Knight Specialty Insurance Company, KSIC, the surety supporting it, is not admitted in New York, which means it is not qualified to receive a certificate of qualification from the Department of Financial Services. James' office led the fraud case against Trump. As a result, KSIC has refiled its documentation in an attempt to restart the procedure. James, according to Golden, referenced a statute that requires either Trump or the KNIC to file a motion in court to justify the surety within 10 days, that is, by April 15th, as April 14th is a Sunday. If not, the bond will be without effect, as per the statute. According to Golden, it is challenging to predict how things will turn out. There is little case law on this particular subject, so it becomes hard to predict what factors a court would consider when deciding if KNIC was truly solvent and could ultimately afford to pay off $175 million, he stated. In this case, Engoron has already set a personal hearing for April 22, 2024, starting at 10 a.m. in the courthouse. The official court records do not seem to indicate what precisely will occur on that date, but news reports indicate that Honorable Engoron will be discussing bond issues, Golden stated. Additionally, 021 senior writer Catherine Fung observed 225 Miles Taylor, a former Trump aide, issued a warning. If the former President Donald Trump were to retake office, he would probably appoint individuals to his cabinet who are prepared to go to tremendous measures in order to forward his agenda. In an attempt to avoid repeating the errors of his last administration, Taylor stated in a Tuesday interview with MSNBC's Morning Joe that should Trump enter office again, he will not select anyone who could work against him. Donald Trump realized very late in his first term that he had far too many people who went to bed and grew a conscience every night and came back in with little inklings of a conscience to say no and push back, Taylor stated. He want for those individuals to be absent. He would much rather have the Oval Office serve as an echo chamber. He will get what he wants because it is what he wants. Prior to this, Taylor was the Department of Homeland Security's chief of staff. During his tenure in the Trump administration, he authored an anonymous opinion piece in the New York Times in 2018 headlined, "I am part of the resistance inside the Trump administration." Taylor did not identify himself as the author until approximately a week prior to the 2020 election while he was running for office against Trump, despite having left the cabinet in 2019. When questioned about Taylor's remarks, Trump's spokesman Stephen Chung told Newsweek, "Miles Taylor is a coward and lives a lonely existence because he's untrustworthy and a liar." Taylor led a group of more than 100 former Trump staffers that opposed a second Trump term. Taylor was the first former Trump official to support Joe Biden in the most recent presidential election.